Porque dijo que pasó cuarto, ¿no?
No, ajá.
Entonces, quinto.
No, estaba en tercero, pasó cuarto.
Oh, ok, entonces cuarto. Sí, sí.
You can keep that thing. That's our logo. Yeah, that's you. Like, show it to everybody.
Just you know.
Could you, yeah, put that. Oh, here. Oh, here you go.
Okay, better.
Okay. Can I go live? Can I go live?
Sure, you can
Okay.
go, you can go live.
All right. Yeah.
Yeah. All right, good. Hello, everybody. So I am Phillip Sparks from the law offices of Phillip Sparks APC, and we're here to have a special ed IEP clinic for the whole day. We are thankful for all of you, being with us and participating in this kind of conference and this consult. So it's a bunch of different parts. We're going to have 4 different presentations. I'm going to be doing the first on Special Education 101, what parents need to know in navigating the process. Then we're going to have Samantha Sosa do another presentation after me, and there's going to be Patrick Gutierrez after lunch. Then we're going to have Maya Gortaras that's going to be doing the last presentation of the day. Additionally, for anybody who wants to get a consult for their IEPs, we're going to have a dedicated room at 1 o'clock on, where it's going to be an attorney there, stationed there. If you signed in at the front for a specific time, and if you haven't, you can go back and sign in, and then you'll be led there, and you'll be able to have an actual consultation with an attorney in the last part of the afternoon. We're going to be providing, right now we have snacks outside, so we have some muffins, things like that for breakfast foods. And then at lunch, we're providing a lunch from Chick-fil-A. So I hope you guys stay for the whole day and enjoy our company, some good information, and I hope we help you. And if we can serve you and help you anytime in the future, we're here for you. We've been here in our office has been open since 2014. I've been practicing since 2012, but I started advocacy a long time ago, right after I got out of law school, and my cousin got an IEP. So that was back in 1995. So we've been doing this for a while, and it's a passion for us because I have a son of my own here, and I have plenty of family that have needed guidance and advocating for advocacy when navigating this process. So my actual thing right now is going to be Special Education 101, a practical guide for parents, caregivers, navigating the process. This will be about a 45-minute session, and please hold your questions for the end. Of course, we started a little bit late, so I would say that if you have any questions and we haven't answered it during the session, come see us afterwards, because we'll be here all day. So the big picture, like I was saying, free appropriate education and least restrictive environment. As we all know, the 2 big fence posts of special ed law is free appropriate public education and least restrictive environment, because the districts are required to provide a free appropriate public education in the least restrictive environment. And what that means is it has to be appropriate to the needs of the student, and it has to be an environment where they're, to the highest extent possible, educated with typically developing peers. Then the common legal frameworks that we deal with in special education law are IDEA, Section 504, and state law. So IDEA is a federal law that came into being. It was originally the handicap education, the Educational Handicap Education Students Act. So I think it was 1975. That's where it started, and then it morphed into IDEA back in 1996, and then it was reauthorized in 2004. And also it's codified in the state laws, in the California Ed Code. And then there's Section 504, which is like a civil rights, it's a discrimination type of law, so that kids with special needs or kids that have any kind of disability are not discriminated against from being able to participate in the programs that typically developing peers can participate in. So how the process starts, the referral and the child find mandate. So let me put it this way. I'm just going to go from my own experience with my beautiful son, Phillip Jr. My son was in first grade and had some attention issues, right? And so the teacher told us, hey, we think you should get him diagnosed, see if take him to a doctor, see if there's anything there that needs help. So we went ahead and went to a doctor. We got assessments. We requested. First, we took to a doctor. The doctor saw there's potential in a diagnosis of ADHD. Also, we got assessments from the district because the district has a child find obligation to assess any students with disabilities who may or may not need services and able to access the curriculum. So with my son, we got the assessment from the district. We had a written request, and after we asked for that written request, they're required to give us an assessment plan within 15 days. And they did that. And then once they give us the assessment plan, they have 60 days to assess and hold an IEP to go over the report. The other thing is I always recommend is, because I'm a special ed attorney and my wife's a school psychologist, we were what you would say we're doing the most. We also got an independent educational evaluation from, I would say, a non-biased source, so that we had both the best of both worlds, a district assessor and an independent assessor. That way we had the peace of mind of knowing that the recommendations were comprehensive and specifically designed to help our child succeed and make progress on his goals and access the curriculum to the best extent. So what fields will be formally assessed, who conducts the assessment, and when will we receive copies of draft reports? Now, these are good questions because in my experience, first off, the biggest thing, usually the assessment starts with the school psychologist from the district. And then they do a whole gambit of tests, and it also maybe with the special ed teacher that's doing educational academic assessment. But they do all these different myriads of things that might affect their ability to access the curriculum. And also it's based upon what they have notice of as difficulties or challenges for the students in the classroom. But there's several different areas that could be assessed. Some of those areas are if there's an articulation issue or fluency issue, something with speech, there's a speech assessment from a speech pathologist. If there's an issue with writing, fine motor skills, things like that, there's an occupational therapy assessment. If there's behavioral challenges, then they can do a functional behavioral assessment, or FBA. And if, for instance, they can't access the curriculum or they can't participate in the average, typically developing peers PE program, there might be an adaptive PE assessment. There might be other assessments if there are some more unique challenges that need to be addressed. I mean, there's always the hearing assessments and vision assessments that are usually done by the nurse. And there's just it depends on the unique challenges of the student that determines what assessment is required. Also, there's a two-part test for whether someone qualifies for an IEP. And it says, does the child formally meet the criteria for at least one of the 13 defined educational disability classifications under the IDEA? Specific learning disability, speech language impairment, autism, or other health impairment. Or, and also, is there an educational need? Does the child require specialized tailored instruction and related support services as a direct consequence of a specific disability? The issue for some students, they might have a disability, they might have a challenge, but if they're able to access the curriculum, there might be a possibility that they don't qualify for an IEP. But there's a lot of things you have to look at to really see specifically whether they need these placement and services to access the curriculum. And it's really important to really get an assessment from an expert to determine that after they do actual observations, to see the meat of the matter, to see whether or not it's really a qualification. What is an IEP? So we have these IEPs, individualized education programs, right? What do they actually say and do? Well, one, what's the story? What's the story? It's like, where are they at? What are they having challenges with? What are their present levels of performance? What are the things that stumble them? What's taking them longer? Are they off task? Is there an issue with social skills? Are there any behavioral challenges, tantruming, elopement, where they're running out of the classroom? What are those things? And so in the IEP, they're supposed to identify where they're at in all of those needs. You're supposed to have measurable goals. So once you figure out what the needs are, what the present levels of performance are, you're supposed to create goals to target those things so they can make progress and better able to actually attend and learn in class and make progress towards those goals, to try to remediate, to make those challenges help so they can access the curriculum and participate in the classroom in an effective manner. And then there's related services. So again, from the diagnosis, from the assessments, if they have challenges with speech, articulation, that needs speech therapy, if they need challenges with fine motor because their writing is illegible, things like that, which will affect their ability to learn or participate in the classroom or actually make progress towards their goals. You need these services to help with those things. Again, who is this team? So we're making a program. Who are the main members of the team? So as it says, it's comprised of the parent, legal guardian, general education teacher, special education teacher, a district representative, and an evaluation specialist. And one thing is usually very intimidating for parents is you get into this meeting, there's a big table of all these professionals from the school, all looking at you, all claiming to be experts on your child, all saying they have degrees, all this experience, all this education, and they're telling you what should happen with your child. It can be intimidating. And believe me, when I first started, I got in those rooms, I didn't have the experience I have now. I was intimidated too. But the thing is, when you're the parent, don't be afraid. You are the biggest expert on your child. Sure, you should get good counsel from other experts in those specialties, but ultimately, they can't tell you about your kid and what they had to eat the night before that gave them a bad nightmare, or the tantruming, or the elopement that happened at the mall. They can't tell you about any trauma experience that might need counseling for, which is affecting their performance at school. They can't tell you all those things because you're the parent. You've been with them since birth, so you're the expert. Don't be intimidated. You're a part of the team, and I would say you are the most important part of the team. So, present levels of performance, baseline and strengths, and how disability affects access. So, the statement should have the current academic scores, functional abilities, peer social interactions, unique student strengths, should reflect objective baseline data. And that's really important to find out the baseline data, because if you don't know where the child's starting from, you have no idea where he needs to go, right? And then you have to see how the disability affects access. So it must explain exactly how the child's identified disability impacts and restricts their overall access to the general education curriculum. Classroom environment and grade levels, learning metrics, because you need to know kind of the what, why, and how. Because if you don't know those things, you won't be able to address the way to make progress, to help the child to become the best that they can be. What progress looks like. So, as I said, direct connection to need. A single academic behavioral goal in the IEP must map directly back to the specific educational deficit identified in the present level statement. Objectively measurable metrics. Avoid subjective wording. Student will improve. Goals must specify the skill. Regular performance monitoring. The IEP must outline how progress is checked. Specify the schedule and reporting. Student updates to parents. So basically, you really have to have good data. That's what it is. You need to know the numbers. You need to know how many times they're off task. You need to know whether that number is improving. Because if you don't know the data, you don't objectively know whether they're doing better. So services and supports. We have special education, related services, and supplementary aids. So with special education, we're looking at the content, delivery, teaching methodologies addressing unique needs and demands. So there's usually these placements, different placements that there's a general ed curriculum where you can get mainstreaming. There's RSP, Resource Specialist Program, where they could be push-in or pull-out. So you could be in a general ed classroom with the RSP teaching pushing in so that they can explain the lesson. If they don't get it right away from the general ed classroom, they can push in and teach and co-teach with the general ed teacher. They can also pull out. So different times during the day, they might take them aside for 30 to an hour to reteach some of the things that were learned. Or there might be a specialty classroom, like there's usually a mild to mod setting that still teaches for general ed grade levels curriculum, but it might be more supportive. They might have actual more aides, more people that can keep them on task and deal with some behaviors. And then there's a mod severe setting, which might have more severe behaviors, or also it might not be the general ed curriculum, it might actually be an adjusted curriculum that's modified. Oh, and by the way, the other part I would say is, outside of that, there's other options for placement. There's, if for whatever reason, an actual campus with typically adult teachers here's doesn't work. There's the possibility of a non-public school, where which has generally students that all might have some disability, and then the other part is either homeschool, or if, for instance, behaviors are such that they can't stay at home with their parents, a residential treatment. So accommodations versus modifications. So this is a great slide in terms of accommodations, where the operational goal, it alters how a student learns and demonstrates knowledge, does not change overall expectations, but modification alters what the student expects to learn or master and changes grading standards. A curriculum standard, student accommodation, student works on the same academic standards as a neurotypical grade level peer. And in modification, expectations are reduced or modified from standard grade level expectation. And so, like standard examples for accommodations: extended school test time, quiet testing group, audiobooks, visual checklists, sensory banks. But modifications: simplified homework assignments, alternate grading scales, reading text below grade level. Samantha, could I get a water? And so, like I said before, the district's proposed to provide a free, appropriate public education in the least restrictive environment, which also means the first place it should be and look at is whether or not they can be educated in the general education placement. So that's the first one. Mainstreaming general education. Thank you. Now, a student should only be removed to a more restrictive, self-contained, or specialized educational environment if their educational benefit cannot be satisfactorily achieved in general education, even with supports. So that goes to the fact, like for instance, if there's behaviors that are so severe that they're going to hurt themselves or others, then that's the situation where the behaviors have to be dealt with in an effective manner with getting an FBA, a functional behavior assessment, having a behavioral support plan, or they might need another placement that's more supportive so that the behaviors can be dealt with applied behavior analysis and those techniques to deal with behaviors and get those remedied in order so they can get to a placement where they can be more integrated with their typically developing peers. Your procedural safeguards. You have the right to participate. So, absolutely, you have the absolute right in the federal law to play a meaningful role in all identification, evaluation, and placement decisions. So, I mean, there's a specific requirement in the law, meaningful participation. And what that usually means, too, is that you have a right to get the reports before the IEP meeting so you can review them and know what they're talking about when you go into the meeting and not be blindsided, blindsided by the team. And that will allow you to have a meaningful role in participation. If not, this is why IEPs might go on for a long time, because you have to read the report to really participate. Prior written notice. It's a legal document explaining exactly what the school proposes or refuses to do and the reasoning behind the choice, what data they use. I mean, it's essential that if they refuse to do something or they're doing something, they should give you a prior written notice of what they're going to do and what they're not. Informed consent. It's a written parental authorization that's required prior to initial assessment and implementation of any of the initial special education placement. So you need to give your informed consent to agree to the program. Every IEP, you have to consent to the program. All right. Now there's issues of just down the line you might experience. The district also has the right to file a complaint with Office of Administrative Hearings where they defend their IEP and request an order from a judge to say that that was what was necessary for the student. So keep that in mind. What if the parents disagree? Unfortunately, I started this late, so I'm going to have to speed up a little bit. So I'm going to do more comprehensive summary because I think I have I have a few more slides, and then I have a whole other presentation that I'm going to be doing right after this. What if the parents disagree? Well, collaborative, request a structural IEP revision meeting. Then the legal target is to renegotiate internal goals and support hours without formal escalation. Alternative dispute, initiate voluntary confidential state-funded mediation guided by a neutral professional mediator. And the target is to establish mutual written agreements with the school district. Formal legal, you can file a formal state complaint detailing administrative code violations or initiate a due process hearing, both of which we do in our office. That way you can get a legal order from an administrative hearing officer or a formal review of the evidence. In a state, it's from the California Department of Education. Here are some practical advocacy tips. You should build a special education binder. Every bit of communications, IEPs, assessments, letters, prior written notices, everything you get from the district and everything you send to the district should be you have a kind of a binder that's a time date stamp of when it happened, what were the details. The reason why I say that is it's imperative for us if you do disagree and we're about to do a lawsuit, we're going to do a complaint in the Office of Administrative Hearings, or we're going to make a case that we do a complaint for the California Department of Education. All that is evidence that we can use to prove your case. And then also commit all requests to writing. Follow up verbal agreements and district promises with structured communication, emails. Always document dates and next steps. This is essential when it comes to creating a situation where you have evidence something went wrong. And then questions parents can ask. What objective baseline data, this is when you're in the IEP, what objective baseline data supports this recommendation? You can demand clinical and classroom measurement data rather than generalize administrative assumptions. And then how will we measure whether my child is making progress? Ensure progress checks are frequent, objective, and documented clearly in the IEP contract. And then can you provide this choice in prior written notice? This legally forces the school team to document and explain why they're declining your specific services. The biggest thing I want you to take away from this presentation is you are part of the team. Advocating for your child is a step-by-step process. Keep records, ask for data, and seek support. So that's the end of that one. And then I have one last one for you that I want to let you know in terms of where we stand as a firm in the process and our vision, our culture, our promise as a firm, in that we've been doing this since 2014. Our purpose and values, our team, and impact, growth, and commitment. Who we serve. We stand with families raising children and young adults with special needs. We step in when systems feel confusing, exhausting, or unfair. Why we exist. Our mission is simple. See your child thrive in school and life. We measure success by real progress, not paperwork or headlines. How we show up, we bring advocacy, guidance, and steady partnership at every step. You are never a case file here. You are family to us. Our purpose and values, Ohana, built on family. Ohana is our standard. My cousin Kenny lived in Hawaii for a long time. He played football in high school in Hawaii. And I remember with Lilo and Stitch and Moana, he used to always say Ohana. He was a teacher, and his community was like a family to him. That's kind of, for me, my vision for my firm, the vision for what we are as parents and families. And our team is Ohana, family. We treat every client relationship like family, not a file. We stay present in the hard seasons and the hopeful ones. You belong here. From the first call, you're welcome, heard, and respected. We lead with compassion, without performative promises or pressure. One spirit, one team. Our internal culture shapes our experience at every step. When we support each other well, we support your family better. Faith, action, community. We lead with love. We serve with faith, compassion, and respect for your whole family. You're treated with warmth, dignity, and a true sense of belonging. We take action. We do not stay on the sidelines when your child needs help. We try, we learn, and we keep pushing for progress. We win together. Your child's growth strengthens our entire community of families. And when we help others win, we win. Impact. Whereas the law firm, a place to thrive. We measure success by children thriving and families feeling supported. We also invest in our team because thriving serves family better. Whole team advocacy. Legal strategy is paired with educational insight to guide decisions. You are supported by attorneys, consultants, and staff working together. We're walking beside you. We bring clarity, compassion, and steady follow through at every step. You get a partner focused on the whole child, not paperwork. The team behind you, attorneys who are called to this work. Our office combines strong advocacy with steady, calm guidance. Many have lived experience in education and community advocacy. Here, Samantha here led a community advocacy thing at her church. My mom was an educator 45 years. I found out myself, I had a speech impediment at a young age, so I had speech therapy. When my son was diagnosed, I got diagnosed with ADHD. This is our experience. So while we don't know your unique thing, we have our own unique thing, and we've learned from it. You have a full team around your child. Paralegals build the record and keep your case moving forward. Educational consultants turn school reports to clear, practical next steps. Our admin team protects deadlines and keeps communications responsive. We understand the system firsthand. Many team members are parents and advocates who have been there. Clear guidance at every step. We help you understand your child's supports, assessments, and rights. We break complex school information into practical, doable options. Educational insight and legal strategy. Educational consultants interpret reports and what services fit best. They connect what is appropriate in school with our advocacy plan. We have a whole team beside you. You see the people working this actual clinic. We're all on your team to help you and your child. Attorneys, paralegals, support staff, coordinate behind the scenes. You are never alone. We communicate, align, and keep moving forward. It's an impact that lasts. Real change for students, relief and clear paths, And how we measure and assess, our benchmark is real progress in the child's daily life. How we are growing from one office to many. This is our flagship office here in Riverside. This was the first office we had. We've grown now, we have offices in Cerritos, Arcadia, we're opening one in San Diego and one in San Francisco. We're all going all across California to serve families in San Diego, Northern California, expanding to serve more families. And we're thinking about going nationally to New York, Alabama, Arizona, and Washington. Why we are expanding? We grow because our families need steady, trusted advocacy. New offices mean help is closer when support is urgent. Where we are headed from the Inland Empire, we expand across California. We're serving more states, New York, Alabama, Arizona, Washington. What will never change? Our values and approach travel with us into every community. Each family still receives a team who knows their story. Our promise: people first, always. We measure success by children thriving, not by statistics. We will be treated like family, heard, respected, and supported. Service you can trust. We show up with compassion, courage, and follow through. We act when needed, because trying creates change. Here now, here next. As we expand and serve more communities, our care stays personal to current and future families. We are here for you. That's my presentation. So, thank you. So, anybody have any questions? We have about another 5 minutes. If anybody wants to ask a question, please. Where's the microphone? Right there. Anybody want to ask a question? You can ask into the mic. Anybody have a question? If you don't have a question now, we're going to be here all day. So after 3:15, I'm going to be in these sessions for the bulk of the day, because I'm in each session with each speaker. But at 3:15 and on, if you still have a question for me personally, I'm going to be here until 5. Sure, go ahead.
Preguntas, ¿cada cuándo es la evaluación del IEP?
My question is, how long is the evaluation?
So, first off, if you have a basic question like what things your child needs to be assessed for, you can request the assessment. You do a written request for an assessment plan. Then they're supposed to give you an assessment plan for 15 days. In 15 days, you'll get a written assessment plan from the district, or a prior written notice saying they're not going to assess. But you should get the assessment plan. And then once you sign that assessment plan, they have 60 days to do the assessment report and hold an IEP to go over the assessment.
Después de eso, de que terminan, ya tienen una respuesta. ¿A cada cuándo tiene que ser otra nueva evaluación?
After they finish, do they have an answer on when the evaluation is going to be next?
Well, first off, there's two things. There's an IEP held every year. There's an annual IEP at the same time from the initial one. Then also every 3 years they have what they call a triennial IEP. And generally those times they do a full reassessment to see if they qualify for an IEP still. All right. Anybody else have questions? Go ahead.
What if there's no changes in the IEP? So from the triennial, they didn't advance educationally, emotionally, and they met no goals. What then?
Well, first off, if they've met no goals, they haven't advanced in any way, or haven't made any progress, then there's an issue. And it's about identifying in an IEP and through assessment tools what those issues are. one, maybe it's the goals are too challenging. So the goals need to be adjusted to be less challenging and more targeted on more incremental change from a starting point. Maybe it's a service that they're not receiving that's prohibiting them from making progress. Let's say it's a behavioral challenges where they're actually not staying on task, and because they don't have an aid that's going to help prompt them to help make their attention be focused, they're not making progress. It could be a placement. There's not enough support staff in their placement for them to make changes towards progress. So the thing is that it's not a cookie cutter answer. It's like everybody says, like the free appropriate public education, it's the unique needs of the child, and that's the reason for the IEP process. That's the reason for assessments. Assessments drive services. So every time you have an IEP and you say they haven't made progress, what's the issue? Is it the goals? Is it the services? Is it the accommodation? Is it new behavioral challenges? Is it a change in medication that has to be adjusted? Is it there's a whole myriad of reasons for it, but the IEP team is supposed to have the experts to help with those assessments to come up with answers that will change the IEP for goals, services, accommodation, things like that, to help them make progress. If they have the same goals all over and over again, and they're still not making progress, there's an issue. Either the goals need to change, the services need to change, the placement needs to change in order for them to start making progress and accessing the curriculum.
Okay, so for the triennial, let's say they do the assessments and they miraculously get the child to use his fine motor skills to open a container when he's not able to, but they document it in the report or the assessments that he is able to. How do the parents go about that?
Well, I mean, the biggest thing I would ask for are logs, and I would ask for notes, and I would ask for when they identified it, and then also I would ask for someone else to maybe observe. A lot of times the parents have the issue is they say, I'm not in the school, I can't see what it is, and they're just telling me what's happening. That's when you get an independent evaluator to go observe in the classroom, so you have an independent witness of what's happening. Additionally, you can ask to go in the classroom and see. And then also, the way you counter it is if they're talking, you ask for samples of things, of work that they've done that demonstrates what they're saying they can do. And then your voice is important too, because if you don't see what they're saying at school is happening at home, then you have an objective reality that you can counter over.
And then I guess my last question would be with the aid. In the IEP, it strictly says he is to have one aid only, because he's only works really well with her, and the school continuously changes it.
Well, that's an issue too, sometimes with administration and with staff, because the other part is, one thing the districts don't have total power over is whether somebody leaves, goes on vacation, gets sick. Some administrative decisions are made for other reasons, and that's why they change it. But the thing is, you get a service, not a person. That's what the law requires, is that if there's a service that's required, you get the service, but you don't necessarily have the right to the particular person. But they have to be qualified. They have to be able to do the job. All right. Well, we're 2 minutes over, but thank you guys for still coming out, and I hope you stay for the rest in the next presentations, and enjoy the food, enjoy the conversation, and we're here for you. So, all right. Yeah, I'm gonna set up the next one.
So do you want to take it?
Yes, it's gonna be about 12 minutes. Oh, that's okay. Again, I'll scoot up. Sure. Here, I'll let you take that.
Mohammed.
Oh, Dr. Shane, you like my presentation?
Yeah, part of it. The thing that I was obviously as a evaluator, I do a lot of these things already.
Right.
Yeah, you got it? Yes, you can see now.
Yes. Yes, please.
And this is her. It's off. Yeah.
Thank you. Now there's no pictures on the tape. It just changed both of them. Oh, really? Yeah. Oh, it changed.
Is this in your shop?
If you try to watch people a bit, you just put them on this side. You know, like we can put three.
Yeah.
Like that. And we move that side there. Well, last, whatever. You can do it. No. They'll listen to you.
Okay, so we'll cut out. We'll cut out. Okay. Yeah. Do you think I can run one of these stores over there? Or
This is live streaming. Live.
you don't like our reorganization?
Just hear conversations.
Oh my god, let me turn it off.
Good morning, everybody. I'm Samantha Sosa. I am the bilingual associate at Law Office of Phillip Sparks. Soy la abogada Samantha Sosa. Soy la socia bilingüe en la oficina de Phillip Sparks. I will be presenting in English, but I do conduct services in English and Spanish for our clients that are bilingual. Before I start, Phil shared a little bit about himself. I'm going to share a little bit more about what did bring me to this area of law. I have a 5-year-old daughter who has autism, is on an IEP, and I found myself as an attorney not being able to adequately help her. This area of law is not an area of law that many know. It's not taught in law school. I had to learn it to help my daughter, and got to the point where I, as an attorney, had to hire an attorney to help me best advocate. So I came to this area having to learn for my own daughter, then was presented people in my community, both through the school and through my church, that were in the same situation I was. God's plans are bigger than mine. This ended up becoming my profession in the area of law I now practice. But I came to this area of law just like you guys, as a parent, needing to learn. I can't even say eager. It was out of necessity to how to best advocate for my parents. So with that, I'm happy to present to you guys our presentation on preparing for your IEP. This is strategy, this is tactical, and what the presentation doesn't speak on is the emotion of what it is to go into an IEP. So before we go through the slides, I want us to be able to all acknowledge when we're going into an IEP meeting, you're going to hear a lot of people sitting around the table who know your child. They don't know your child like you do, but also you're hearing a lot of deficits. We always start with, what are their strengths? What improvements have you seen? And it's a nice, lighthearted way to open a meeting, but then the rest of the meeting is goals they didn't meet, or maybe goals they met, but they're still 2 grade levels behind their peers, and it can be a lot. So going into this meeting prepared for what the data is going to show, what questions you're going to have, and seeing the reports ahead of time, looking at their progress reports throughout the year, will help you digest the emotional, cry over it if you need to, and start to be able to develop those intelligent questions so when you're in the meeting, you're prepared for what the data is going to show. Because regardless, this is your baby, and it's a lot to take in. So when we're prepared with all of the information, it makes us better advocates for your kid, because you can't hide the emotion, you can't take it away, but if you give yourself time to process it, you can take this information we're going to give you and go in your child's best advocate with the fuel of the emotion behind you, rather than sulking in everything you're taking in, and then the meeting's over and 3 hours later, now you get your question, right? So it is your right to have meaningful participation in the meeting. So that goes to what we're going to talk about today. So when we're preparing for an IEP, you need to know, what do you want to get out of it? You want it to be a collaborative process, right? You want to be able to take the information and ask questions and give your 2 cents so that the teachers understand where you're coming from. We want to make sure that you're using your time effectively. Not because you have to limit to what you want to say, but it's hard to get so many people in the room. The longer that an IEP meeting drags out, the longer it's going to take to implement those necessary changes for your child. The district only has to start the IEP process by its due date, but they don't have to finish it. So it tends to drag out a lot longer when it comes to, so knowing, being prepared with written concerns, written parent statements make a big difference. Being prepared helps improve the outcome because you're able to advocate for your child in the moment with everyone in the room, and you can help clearly define what the educational services that are needed by your student, and then you also want to be able to know what you have to follow through. So this is what you should be taking into consideration when you're preparing. You're going to be collaborative. You may have not had the best rapport with the teacher, but you're there to collaborate with the whole group. You want to make sure we're using your time wisely for your student, and then afterwards you're going to hold them accountable. Know how to follow up and not just sit back for the next year to come. So the purpose of the IEP meeting is always to either first develop, it's the very first one, review, and see what changes need to be made to your student's individual plan, right? This is where your student meets their needs, where we're going to find where we need to address, whether it's social emotional, whether it's academic, whether it's behavioral, whether it's tactile and sensory. What is stopping your student from accessing their education? And remember, when we're talking about accessing education, it's not just academic. It's, can they stay in a classroom and participate in circle time? Can they go to passing period and go from one class to another when they're in middle school? Do they have friends? Social learning, it doesn't start and stop in the classroom. It's their full range of education. So education and academics are 2 different things. With parents being very active in the IEP process, asking questions, proposing changes you can take goals in, and also explaining disagreements that you have in the meeting, it really helps to facilitate that collaborative conversation between service providers. When you're sitting in a meeting, you go person by person by person, and everybody's talking about their own specialty. It's not necessarily collaborative because only one person is talking about their one thing. But a lot of times our child's needs are multifaceted. Do they have a behavior issue that's making it difficult for them to be able to do OT? And that's why they haven't improved in their OT goals, right? Is there, do they need a one-on-one so that they can do speech where they currently don't take their one-on-one to speech? So asking those questions and forcing the service collaborators to make sure that they're talking will make sure that the services are collaborative as well. Goals can be written and be assigned to more than just one person. You can have a speech goal that's being worked on by speech and behavioral, a BCBA or a BT, because they have difficulty sitting in the speech room, or they have sensory needs. So then OT needs to collaborate with the classroom so that they have a chewy, or that they have a chair, like a band on their chair, so that they can have sensory input or output depending on what they need. All of our IEPs are data driven, but the data doesn't only have to come from the schools. It is based on their current academic performance, it's based off of evaluations, and it's based off of their specific needs. If it's not a triannual, the data is coming from what the teachers are taking down. Who's taking it down? If they don't have a one-on-one, is the teacher being able to collect appropriate data? How long were they collecting that data before the meeting? Was it the week before? Do they do it every day? But also as a parent, you bring a lot of data to the table of things that happen outside. So when we're talking about you having a role in your student's IEP, you have unique insight to your children's ability and needs that you fill in as a parent. And a lot of times as special need parents, you're just being a parent. You're not a special need parent. So you don't think about all the things that you have to change in your everyday life to serve your student. But in reality, are you thinking, we have to go to the grocery store after 7 o'clock, after the dinner rush, because they get overstimulated by too much noise, and I won't be able to make it through the store beforehand? Do you have to say, I need support to be able to put them into this art class, to make sure somebody can be there with them, because otherwise they can't collaborate? Or vice versa. Are you able to leave your child at a church nursery or any sort of class, and they're able to participate just fine because it's a smaller learning environment of 2 or 3 kids? All of those things are things that you're doing at home as a parent, that your student's able to have access to lots of extracurricular activities, live daily lives. But in reality, all of those things are accommodations that you're changing in your day-to-day life so that your kid can have a full round life. Bringing that data into an IEP meeting can show how much growth your child can do when they're given appropriate services. So, for example, my daughter is now in a general ed class with a one-on-one. She has a lot of social emotional needs. And oftentimes it's easier to just give a child what they want so they don't have a behavior and they don't have an outburst, and things go a lot smoother. But that delays growth. So I love to open an IEP meeting with all of the things my daughter is doing outside of school and how minimal support but strict and firm preparation, priming, framing can help her, right? Because just like Mr. Sparks shared in our last presentation, when we have services, we're guaranteed a service, but you're not guaranteed a person. So you can have one-on-one that does nothing for your child because they're not there to fully support them. They're not pushing them, they're not helping them cope, they're not working through the things that your child needs support to learn, because ultimately the goal is independence. So if the person is not doing that, you're going to be having the service for years to come, but there's going to be no improvement at the end of the day. They may be able to access the education, but what happens when we're moving on and they're getting older and they don't want to have that support person? We have to make sure they're doing the work. Being able to see that and communicate what it is that you do and what your child's needs are and why changes the game when it comes to sitting in an IEP meeting and participating. It can trigger ideas. It also is a good way to allow the school to let you know what they already do. A thing that we hear a lot, we're talking about collaboration, advocacy, and accountability. A lot of times, especially elementary school, lower middle school, we'll hear from teachers, well, we do that in the classroom already, so we don't need that to be an accommodation. Oh, this, we already have this communication in place, so we don't need to do it. I think it's great that you have that in place already. However, we know that this helps my student thrive. God forbid we have to move. There's a new teacher. We want to make sure that they know what we're doing. Everything that we're doing now that's helping them meet their goals, that it stays there. You're going into that with an attitude of collaboration, right? But on the other end, this leads into accountability. If it's not on the IEP document, you have no way to hold them accountable to that service or to that accommodation. When we're talking about the advocacy, collaboration, ensuring accountability, anything that you can possibly get put into the IEP, whether it's a service or a related service or an accommodation, is really important, because that's going to let the rest of the team members know what we're doing. Because you may have a great speech therapist that is in tune with behavioral needs, and an OT who came from a clinical background, not an educative background. So they don't know how to use those strategies across services. Or you have a teacher who maybe is used to a mild, moderate program, but now they're teaching moderate to severe, and they're not in tune with what can work for your child's needs. So bringing those up, putting them in the IEP, make sure that everyone is on the same page on how we're working with our kids. So with that, who is that? Who's participating in our IEP meetings? Like we said earlier, we have the parents, gen ed teachers, special ed teachers, a district representative, and then the authority over services. What does that mean? What's authority over services? It doesn't necessarily have to be your child's speech therapist. It doesn't necessarily have to be the person who's providing that service, but somebody who oversees it. Sometimes you'll have, a district representative or a coworker if it's from a third-party agency. The IEP can go on, and you may not have that person that's actually there with your student, but they should be armed with the data, the examples, the logs. They should still be able to fully participate. Sometimes it's frustrating because you want the person who knows your kid. But I do have to just say, that's not grounds to not have the meeting. However, you're entitled to that communication. So if they can't give you that communication, they owe it to you. So you can ask for a separate call, you can ask for it via email, you can ask to meet again when that person is available, and excuse other members of the IEP team that don't need to be there. But those are your core group of participants. The specialists who interpret the evaluations is not always the evaluator of that evaluation. You have school psychologists that are assigned to a different school, moved to a different district. They did the FBA a month ago and now they're no longer employed. So the reports should be written well enough so that somebody else can come and interpret that data. And if it's not, then that's a grounds for an IE, which we'll talk about later on in the day. There's a lot of things that are very interconnected. Students can also be in the IEPs. Most parents will opt out. Others will, depending on where the students are. If they're 15 and they're in high school, and it's very important for the parent, for the student to be able to learn how to advocate for themselves, and they're in that phase of their life where they may be going to community college, they may be able to get a job, but they're going to need accommodations. Having a student sit in an IEP and understanding that they're entitled to certain accommodations in the classroom and beyond can be also very empowering. But also a student who may not be ready social-emotionally, it could also be detrimental. So you have a right as a parent to invite your student or not. They're starting about 15 is when they start to ask if you want the student there, and they can also sign they won't be binding unless they're 18 or older, but there's a place for them to sign for participation. Attending transition meetings is really good for the student when they're going from high school either into college or into a vocational program, because they can kind of see the difference. Also, transitional IEPs include the new service providers, a representative from the high school, a representative from the Department of Rehabilitation. So they can also ask questions or at least be in the room. And then making sure that you're informed about the attendees beforehand. How do you do that? You're going to get a notice of meeting that you sign when they confirm the date. In that notice of meeting, there's just a whole lot of words, right? It has like the date and time at the top and a place for you to sign at the bottom that says you'll be there, you need another date, you'll be there virtually, or you're bringing your lawyer, you're bringing an advocate. In the middle part, will tell you who's coming. It'll tell you either their name or their title. We're going to have a school psychologist, a speech therapist, a gen ed teacher. If your student has medical needs and you don't see school nurse, that's your time to say, hey, we have a medical action plan and I don't see the school nurse. Can we confirm that the school nurse is going to be there? And just keeping a mental note of anybody who can facilitate a service of your child, that they're there. So, notice a meeting, you confirm the meeting. At that point, you can request that your draft and any evaluations be given to you ahead of time. You can ask for a week, you can ask for a few days. Typically, you go for a couple days. A big winner here is asking in a written format, whether that's an email, whether that's Parent Square, Google Classroom, however you already communicate with your child's case carrier, to ensure meaningful participation. I'm requesting a draft of the IEP prior to the meeting. I'm requesting a draft of the evaluation so that I can review it and have intelligent questions to ask. Your legal right as a parent is to meaningfully participate. And if you're not a school psychologist and you're not a speech therapist, you as a parent may not be able to meaningfully participate in those sections of the IEP. So using those key trigger legal words, it's not a threat. It's just letting them know, hey, this is very informal for you because you do it several times a month, but this is my annual marathon that I have to do for my child, and I'm preparing myself the best that I possibly can to do it. When you're reading those drafts, I'm a big paper person. We're very techie in this firm, but I like to print out, I like to highlight, I like to have my questions. Some questions may just be a call for understanding, and other things can be, I have never not once heard my child say that. I completely disagree with this statement, and their mistakes are made. Some evaluations get copied and pasted from others, and they may have a name of a student that's not yours in there, or there may be a page that just doesn't make sense. So call it out ahead of time, so when you get there and you review it, you're able to get those questions answered and don't just assume like, wow, this is going to be bad. When you're looking at their current IEP, your current IEP has their goals for the year. It also usually at the back, will have the goals of the previous year before they were working on and where they were at. So if you're looking at one IEP document, you can see almost 3 years worth of data, right? If you have a complete draft, you have previous year's IEP goals and whether they were met. You have the current year's goals that you signed at the last IEP meeting, and you should have some progress, right? The short-term objectives. So you should be able to see kind of where you're at. The goal may or may not, the draft may or may not already have their present levels or where they ended the year. It's a draft, it's not a final version. There's a lot that you can gather from there. We also get progress reports, academic, and you should be getting progress reports on your IEP. Make sure you have those. And if you don't have them or you toss them, you can request a full educational record for that year or the year before, and you have to get it from the district within 5 days. So you can review it before your meeting, even if you want to look at where they were before to be able to compare. look at any samples that may have come home, whether it's informal, whether it's also samples of things. If your child is ABA outside of school, they have OT outside of school, you can take that with you. And then any other medical evaluations, if you have outside service providers, talk to them beforehand. Tell them, is there anything that you think I need to make sure they're doing at school? Is there something that you implemented recently that you feel is working that I should be sharing with them at school? Have both teams work together, so you're able to understand as much as possible the data. What is the data again? It could be tally marks of things that are collected in the classroom. Off-task behavior. Was your student off-task? It took 1, 2, 3, 4 prompts to get the student back on track when they were up stimming, didn't want to transition to a new activity, right? Having all the different, not just the full reports, but those individual little data points can also help guide the conversation. If it is an IEP that's going to include an evaluation, whether it's a triennial, whether you requested a new evaluation, for example, for assistive technology that your student never had before, or for a mental health assessment, check those evaluations and make sure that if there is a disability that your child currently isn't getting services for on their IEP that's listed there, that it includes evaluations on that. Sometimes you'll get an evaluation that'll mention suspected dyslexia or dysgraphia. Well, what did they do to rule it out or to rule it in? Do you have to request further evaluations because they threw something out there that you've never heard before? They may say your child may benefit from an ERMS report, which is an educationally related mental health report, but then you only see that in one sentence and you never hear from it again. So when you're reading, you highlight these things so that you can bring them up and say, hey, this person said something about an ERMS, can we talk about that? Do we need I want to request that assessment? Or did you rule out that you didn't? We know that they couldn't have done the assessment without you signing an assessment plan, but you want to make sure that all suspected areas of disabilities are covered. And then align the observations, what you see as a parent, what you may have heard from your teacher in other communications, to the results. And if they are spot on, congratulate the team. Let them know, I agree with this, this is what I see. I feel we need to focus on these areas. And if they're not, call it out. I haven't seen these issues before. This is something that's concerning to me. Could it be a different environment? I will counsel my clients. It is not uncommon that you have one student at home and one student at school. So sometimes they'll perform for their teacher, for their speech therapist, and for mom. Despite all of your work and all of your research, they just don't want to. And that's just sometimes the way it goes. But it shouldn't be everything, right? Overall, I have yet to be in an IEP meeting that's 45 minutes, but I like to ask for a minimum of an hour for personally, not just for my clients. I attend my daughter's IEP meetings alone now, and I ask for a minimum of an hour and 15 minutes. And the way I do that, if they give me an hour, they give me less. So to ensure that we're finishing the IEP meeting and we can avoid a second meeting, can we make sure I have all drafts, all evaluation reports, and can we maybe schedule an hour and 15 minutes just to make sure we can finish and don't have to come back? We should be looking at 1 to 5, maybe even 1 to 10 on welcome and goals if you as a parent are taking new goals. You can go armed with your own goals to an IEP meeting. If you don't think your kid's making progress in a certain area, let's say there's a lot of concrete areas of need. Fine motor. We're working on having the student being able to hold a pencil correctly, And then gross motor, we want to make sure that they can be comfortably seated and not get up all the time. And then there may be a behavioral concern. Those are probably needs that are addressed in the IEP. But as a parent, you may see, wait, my student is 8 and doesn't really have friends. I don't see my friend. When I go to pick up, I don't see my student playing with someone. So maybe you want to bring a social emotional goal to the IEP meeting. Allow yourself the time in the beginning to say, I know this is what we're working on. I'd like to also, talk about writing a goal in this area. You don't have to have a fully written goal. You can, if you want to sit down with someone, if you have an attorney, if you've done an independent evaluation, you can write a goal and then figure out who in the team would be the one implementing it. But you can also say, I also want this for my child. Not all IEP teams understand that they're there to support the whole child, right? Their friends, their social emotional, their excitement to be at school is something that we want for them as parents, and that support can come from IEP services as well. Remember, this is access to their education. They've got nothing else to do from kinder to 18 but to be able to have a full education. The team will go over parent rights. Every IEP you're supposed to get your procedural safeguards, and then they'll introduce the team as well. If somebody's not there that should have been there and you didn't excuse them, you need to make note of it. You have a right to stop the meeting and not move forward if they're an essential part, but typically, as an attorney, I say that we push forward and then have a second meeting after, make sure that it's noted, because you don't want to lose that time where everybody's always in the room, right? But you do want to address it. We don't have a general ed teacher here, and I think my child needs some mainstreaming time. So I think it's important that we have a general ed teacher here to be able to weigh in on that. They were supposed to be here and they're not. Then you move on. Don't hold, we don't hold a grudge in that moment. In general, if you're my client, you'll hear me say this isn't the time for the fight. There's a time and place to bring certain things up, and going into the IEP meeting with an attitude of collaboration is really important. So you say what you need to say, you get it in the notes, but it doesn't end there. Nothing can happen without that signature, so we have time to move forward. Make sure that, again, you reviewed everything that you could before the meeting, you build your agenda, make sure everybody who has to be there. After the meeting, you want to make sure that you are getting follow-ups, and monitoring. We'll go into that a little bit later. If you're a parent who knows, and this is where we have to really, as parents, dig deep inside, be very self-aware. Do you break down when it comes to your child? I have a friend who's such a fierce IEP advocate, and she cannot do it for her own kids. She will call me right before she's going to go in the room, nervous already, I'm going to puke, I can't do this. And I have heard her get amazing services, evaluations, do ADRs, but when it's your kid, it's your kid. So can you take everything that you prepared and can you communicate that, or can you not? Because you can create an agenda, you can write a parent action plan, you can handwrite what you want to say verbatim, or you can write it out and take a family friend with you to read it. There's a lot of possibility, but understanding that before you go in is really important. Make sure that you have your priorities in check as far as what's working, what's not, what do you as a parent want to make sure that is discussed in the meetings. I often like to say, this is what my agenda is. We can discuss it when it comes to the correct service providers, but let me please say that I'm concerned that there hasn't been much improvement in fine motor skills. I've seen a regression in speech, and I think that we may need to be changing mainstream minutes. Those are not all going to be, they're not going to talk about each of those back to back to back, but now we know when we get to speech, you have a concern about speech. When we get to OT, your concern was fine motor. It's noted in the notes, and then you move on, and you can address it when you can. Make sure that you're setting expectations. By doing that, you already set the expectation that you're gonna collaborate and that you expect the same from the service provider. When we're looking at goals, you as a parent should be able to understand them. So take a moment, read them, especially when it comes to measuring them. You'll sometimes hear in 80% of opportunities over a 2-week period with testing every 3 days. Okay? What does that mean? If you don't understand how to measure them, somebody who's collecting data may not understand how to collect the data for that if they didn't write the goal. So the goal overall may be a good goal. You may agree with what the end game and the objective is, but you may not understand how that is going to be measured. Say it. Ask for it to be able to be written that way. We have short-term objectives that build on each other for a reason, so you have that check-in point, right? Is it realistic? Are we doing stepping stones? Or are we front-loading and then all of a sudden expect the back end to just stop? Because if the goal isn't going to be something you think they're going to do in the whole year, make sure you note that, because if they reach it at a short-term objective but they've met the whole goal, you can have an amendment meeting to add on to that goal, right? So just make sure that you understand them and that they're very clear. We talked already a lot about participation, being prepared, talking in that meeting. Now, what if you disagree with someone is telling you? It's two-pronged, right? In that moment, you may have a highlight on your printed out draft that you disagree. One, that may not be your kid, the kid you're talking about. Two, they may be saying progress has happened where it has not. A good concrete one is when the kids are younger and you're talking about number recognition or letter recognition, and they list out particular letters that your child allegedly can recognize, and you're like, we just did the alphabet and we got half of those, so bringing those disagreements up in the meeting, first thing it'll do, prompt them to share a little bit more about their data, how they collected it, why. Maybe it's something that they do musically and your kid can identify things if it's a rhythmic song. So when they're going through their, that's a C, da, ga, 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 however it is, there may be something they're doing at school that you don't know that they're doing, that your child truly has met that goal, you just don't see it at home. Or the data collection maybe wasn't necessarily right. If you disagree with services or offer a FAPE, you could bring it up in that moment as well, and why. I don't think we should be backing down speech. I think we need to add other goals. Maybe we keep the minutes the same, but now we have expressive language and receptive language, but my child can't hold a conversation other than, how was school today? School today was fun. What did you do? I played with my friends. What did you and your friends do? We played toys. That's my daughter. Her receptive language scores have gone extremely high, but her expressive language and her pragmatic language are not there yet. So we see a big leap somewhere and a service provider gets really excited because they've met their goals and they're ready to move on, but they're not moving on in that, they're moving on to another area of speech. They're moving on like, we did it, we're good, we're done. So bringing that up. Then understanding your rights. The meeting may end. You don't have to sign that you're in agreement with all of those things. You can wait until after the meeting to, you can do amendments, you can edit via email, you can say, I'd like more data on this before I sign that we can remove this service or not. I can ask for an independent evaluation if you don't agree with an evaluation. Until a parent gives consent, the previous IEP is going to be in place. And you can also sign for consent for some things, but not the other. So let's say your child is going to be given an AAC device per this offer of FAPE, and you want that device, but you don't agree with the goals, you don't agree with removing a said service, you can sign, I agree only to implement an AAC device, speech, XYZ, and the rest will remain open until you can discuss it. If you have an attorney and you have an advocate, this is where we thrive. This is where we can push for that. There are a lot of things that happen after that are not necessarily part of this presentation, but we can discuss that. If that's where you're at, we'll be here till 5 to discuss how to help you accomplish when there's a complete disagreement within a team that's stopped at a standstill and you're not going to be able to implement that IEP. If you're happy with an IEP and you sign it and you implement, what's next? What's implementation mode, as we call it? It's making sure that what you decided based off of all of this data and all this conversation is actually working for your kid. So you give it a little bit, 30 days. There's always a honeymoon period when it comes to new services, new people. Then after about 30 days, your kid will kind of show their true colors and be like, yeah, no, I like this one-on-one, but now they're still here, and I'm going to go back to my behaviors before. Okay, do we need to adjust certain things? You can ask questions. You're entitled to logs of when the services are being provided, what they're working on in the services. Behavior logs will show how much were they prompted today, how much off-task behavior. You can start to look at patterns that come. Oh, well, I thought that they really liked art. Turns out every time they go to art class and they transition, my kid has a behavior. Is it the transition? Is it that they're not being primed? Or is it that art really isn't a preferred activity and we were thinking that it was, and we have that as an elective or a reward, and it's the wrong thing? And then just request follow-up meetings and data as needed. So you as a parent can call an IEP meeting for parent concerns, and the team has to meet within 30 days. The more information you give them up front, the better that IEP meeting you call will go, because you actually have, you gave them a little bit of info for them to do their homework. Just like you were prepared, they should be prepared to help address some of your concerns. You may not leave that meeting with everything addressed, but maybe a plan, maybe a change of a person, or maybe an evaluation will come out of that by moving on. So have your checklist, make sure you have the date, make sure you know who's going to be there. You can take a support person with you, whether that's your attorney, an advocate, a family friend, and know your own needs, your own limits when it comes to advocating for your kid. Any extra information you take is also evidence. So those anecdotes about your kid, the things that you do outside of the home, outside of school, to make sure that your kid has a whole and complete life. And then just avoid very common mistakes. Not being prepared, not reviewing documents that you have, or not signing when you do agree. Make sure that you leave a meeting knowing who's in charge of what, and that you really understand that those goals that they're going to be working on for the next year. So a parent, review the IEP, the school, make sure that they begin services as soon as possible, and then you're constantly monitoring progress. Went a little bit over, but does anybody have questions?
Sorry.
Can you pass me the mic?
Sure.
Okay, what if you make a formal request? I submitted plenty of requests asking for the data, asking for the district to submit data and to send over the data to the parents, and it was ignored over and over and over again.
So the first thing I would say is you need to file a California Department of Education complaint. So Phil talked about it in the last session a little bit, and things that happen. You can do that alone as a parent. You can have your attorney do it with you. What that does is, the nature of that complaint is you're giving the facts to the California Department of Education. What you asked for, when you asked for it, maybe why. The why doesn't matter as much as what and when. And then any supporting data you have. Here's a screenshot of a Class Dojo message. Here's a copy of an email that I sent. Here is me saying that I did not get a response. The California Department of Education then has to investigate that, usually about 60 days. So now they're asking the school district for clarification on what they did and why. They will give an objective determination on what rights were violated or were not and how. So that is something that a parent can do for free. There's guides online from California Department of Education. It's a PDF. It tells you how to fill out the form, what to send off, and then how to follow up. That piece is very important because it holds the school districts accountable. It's kind of like a running tally with Department of Education, and if the districts are constantly getting the same issues, it can be that the California Department of Education is going to step in, because you're likely not the only parent that's having that issue. So then you can take that determination. This is a step further. This is where like your lawyers also come in. If there's not just rights as far as logs, but if it's also, it turns out you get those logs and your student was missing minutes and hours of services, that Department of Education complaint with that objective data can also be used when you go to ask for compensatory education in one of the means of following up, whether it be an ADR or a complaint with the Office of Administrative Hearing.
She also wanted me to ask if she requested a report because there was police involvement, the child was hurt, and the school district refused to provide it to her. The school refused to provide her the report. And then they told her they had filed an accurate report when it was received at the following IEP. They completely denied what was written in the police report from the RSO. And they're still refusing to provide an actual report of what happened that day at the school. The principal will only tell them in writing. It's not in writing, in verbal, but will not put it in writing.
So,
and it's been requested in writing.
If it involves a school resource officer, if it involves another outside agency, that falls outside your general guidelines when we're talking about special ed and IEP, and you have to request them directly from the RSO from that agency, right? And then there's separate civil penalties for them not releasing and giving it to you. Now, if those issues turn out to be that they're not giving you, you don't have the information, and now you get this information from the district school resource officer, right, or from the county sheriff, whoever was the one that shows up and takes the report, and that gives you vital information to show that a need wasn't met, a service wasn't held, they were supposed to have one-on-one and they weren't there, then you can take that information into your IEP for adjustments, comp ed, but they start in two separate places. So there's also civil rights violations that are outside of your REP, your IEP special education rights. So with our firm, we focus solely on IEP services and when it relates to that. However, sometimes there are overlaps when it comes to civil rights violations and such.
Yeah, because she did get the reports from the police station, and when presented at the IEP, the principal and another staff, the teacher I believe, completely denied what they had reported.
So that's something that's super individualized. I encourage you to take advantage of our one-on-one sessions. Are we going to have this after?
I signed up twice.
Yes, so since that's a very pointed, but in general, just for everyone in the room, there are different areas of the law that overlap within school. There's also civil, not just civil rights violations, but when the school has your child, they're acting in loco parentis. So if they're neglecting your child, that's another civil violation that you can pursue in civil court if there's an injury or something that occurs. So if there's something big, if you get an attorney on the other end, we would overlap in the areas that they do, we don't handle those here. But there are nuggets that we can help piece together for you and make sure that you get the other support you need.
Yeah, right now we're primarily, specifically special education. We file compliance complaints in California Department of Education. We also file due process complaints with the Office of Administrative Hearings. And we've done some general ed with suspensions and expulsions. And we also basically stick in that lane right now. But we are pursuing, considering other civil rights violation filings with OCR and also some civil litigation in the future. So that's something we're going to explore for that. Additionally, we're trying to become a one-stop shop because we're looking at doing estate planning conservatorships and a little expansion into entertainment law because so many of our kids that have with different abilities or so have artistic gifts. So these are some things that we're going to explore in the future for our firm, but those are definitely things you would want to pursue in those other arenas because not everything's covered by the special education law spectrum. But civil litigation sometimes has that leverage against these districts for other remedies.
Okay, so I think we're breaking for lunch now?
Yes, we're
Okay,
breaking.
so we're breaking for lunch. Thank you all for coming. Please enjoy a meal. If you signed up for a one-on-one session, bring your questions, and then we have 2 more sessions for Sunday. Thank you all.
So sorry.
Nice to meet you, Samantha. I just need to report on Asheville
Oh, please, can you close the door?
Close it. Okay, I'm turning on live. 2, 3, 1, go.
Hello everyone. Today I will be talking about the history of special education law and common issues that parents often encounter during IEP meetings. So I'll be providing a quick little overview of the development of U.S. special education law, focusing on key statutes and cases that helped shape the rights of students with disabilities. And so to kind of frame this, special education law is both a civil rights regime and an individualized educational planning system. The attorney's role is not only to litigate disputes after they come up, but to help ensure that the IEP process, especially for parents, is informed, is collaborative, procedurally sound, and focused on measurable student progress. So before we get into the cases and statutes and the details, it's important to understand why this history matters. Special education law did not develop in a vacuum or come out of nowhere. It arose because students with disabilities were routinely excluded from public schools or provided inadequate or deficient services. So the modern legal framework that we have now reflects a compromise. It creates enforceable rights on the one hand, but it also relies heavily on collaboration throughout the IEP process. And that's why parent participation, evaluations, procedural safeguards, and team decision-making are all built into the laws themselves. And so the key takeaway is that the IEP meeting is not simply an educational planning meeting. It is the primary legal mechanism through which a free, appropriate public education is delivered, and through which disputes are either resolved or preserved for future litigation. So, special education law in the United States developed from a period when many children with disabilities were excluded from public schools, and it transformed into a federal rights-based system requiring public schools to identify, evaluate, and educate eligible students with disabilities. And so the central framework today is the Individuals with Disabilities Education Act, or IDEA, IDAA. So before there were federal statutes, the education system was very, very exclusionary to students with disabilities. Children were routinely excluded from enrollment. Those children that were allowed in schools were often segregated in warehouses with zero academic instruction. And so civil rights advocates turned to the 14th Amendment's equal protection and due process clauses. And there were a couple cases in the 70s, Park versus Penn and Mills versus Board of Education, that declared that that exclusion of children with disabilities was unconstitutional. So these cases predate the modern Individuals with Disability in Education Act, but they created the conceptual foundation for later federal legislation. And so access to school, individualized decision making, procedural protections, publicly funded services. In 1975, President Gerald Ford signed the Education for All Handicapped Children Act, guaranteeing a free and appropriate public education for children with disabilities. And in 1990, IDEA was signed into law, and this established the concepts and the guarantees of FAPE, the IEP, least restrictive environment, and procedural safeguards for parents and students. So the IDEA established a comprehensive statutory framework designed to ensure that eligible students with disabilities receive a FAPE that is tailored to their unique needs. And central to this framework is the IEP itself, which is a written document developed by the team that includes parents as equal participants. And the IEP has to be grounded in accurate present levels of performance. It has to identify the child's disability-related needs. It has to set measurable annual goals. It has to specify the special education, related services, accommodations, and any other supports that are necessary for the student to make progress. And there is something called Section 504 of the Rehabilitation Act, which bans disability-based discrimination by recipients of federal funding, such as public schools. And Section 504 and IDEA are related, but they are distinct. IDEA is more of an affirmative entitlement to special education and services for eligible students, whereas Section 504 is a broader anti-discrimination protection and can cover students who otherwise do not qualify under IDEA. So the first seminal case in special education law that was decided by the Supreme Court was Board of Education versus Rowley, which was the court's first interpretation of what a free, appropriate public education means. And so in their ruling, the court decided that schools must maximize, or they rejected the idea that schools have to maximize a student's potential to match non-disabled peers. And they established a two-step process to decide whether or not a student received a FAPE. So did the state comply with statutory procedures, and is the IEP reasonably calculated to enable the child to receive educational benefit? And so what a benefit means, at least for the Rowley case, is it was more of a basic floor of opportunity, consisting of having access to special education. And for districts, or for decades, schools often emphasized Rowley's rejection of maximization. And parent advocates and lawyers often emphasized that just because their program doesn't have to be maximized, it should still provide some access and individualized benefit. And this kind of tension between some benefit and meaningful progress set the stage for later disputes. So related services, in Irving versus Tatro, the Supreme Court held that services required to enable a child to physically access school is what related services mean. And services have to be directly linked to the child's ability to access the program. So if a student cannot access the classroom setting without health-related, therapeutic, assistive supports, the IEP team has an obligation to treat those supports as mandatory entitlements and not just optional programmatic add-ons. So in meetings, it's important to avoid allowing like related services to be discussed as isolated minutes, because each service has to be tied to the student's needs and access barriers and goals and their ability to actually make progress. In terms of discipline, in Honing versus Doe, the court restricted a district's ability to unilaterally suspend or expel students with disabilities for misconduct that was a direct result of their disability, establishing the stay put protection during disputes. Basically, the children's setting that was agreed to at their that was consented to at the last IEP is their setting until otherwise decided by the parents or court. And this decision led directly to the statutory what's called manifestation determination review, and these are meetings held between the school and the district when the school is suspended or when its child is suspended or expelled, and where schools have to basically determine whether the child's behavior that led to the suspensions or expulsions was a manifestation of their disability or instead a direct failure of the school to implement the student's IEP. And so the modern manifestation determination meetings, they kind of reflect the same underlying concern. Basically, schools need authority to maintain safety, but on the other hand, disability-related behavior cannot be handled simply by expelling the student. In terms of fees and remedies, in Smith versus Robinson, the court ruled that basically attorneys couldn't get fees, and they needed to get them through other civil rights laws. And Congress immediately responded by passing the Handicapped Children's Protection Act, basically allowing parents or attorneys on behalf of parents to get attorney's fees so that they could actually bring cases against the district in due process hearings, for example, through the and California through the Office of Administrative Hearings. So special education law has evolved through continuing dialogue among Congress, courts, agencies, school systems, parents, advocates. The history of special education law is very much a progression. And first came the right to attend school, then came the right to individualized services, procedural protections, placement in the least restrictive environment. And today, the key question in any IEP meeting is whether the IEP is reasonably calculated to allow the child to make progress appropriate to that child's circumstances. So the modern framework, of course, was the Individuals with Disabilities in Education Act, which established both which established both parent rights and the modern FAPE standard, or Free Appropriate Public Education standard. So every IEP should answer these 5 questions. Is a student eligible under IDEA? Has the student been evaluated in all suspected areas of disability? Does the IEP provide a FAPE? Is the placement for that child in the least restrictive environment? And were parents afforded meaningful participation and procedural safeguards? So although IDEA is a large and complex statute, most disputes ultimately come back to these 5 questions. And when I review a case, I usually start here: eligibility, evaluations, FAPE, least restrictive environment, parent participation. These 5 questions also provide a useful framework for analyzing nearly every due process case. Most disputes can be traced back to one or more of these rules. And keeping these questions in mind helps us identify where or how the district's decision-making process broke down, and where additional evidence may be needed. So if you remember nothing else from my presentation today, remember these 5 questions, because almost every dispute can be analyzed through one or more of these lenses. So the modern FAPE standard was established in Andrew versus Douglas County, which radically redefined the standard for what constitutes a free, appropriate public education. And this case is relatively recent, only 9 years ago. So they rejected the idea that just because we don't have to maximize a student's potential doesn't mean that we only have to do the very bare minimum. Instead, the IEP basically must be reasonably calculated to enable a child to make progress appropriate in light of that child's unique circumstances. And for many children, that means progress in the general education curriculum. And for children not fully integrated in general education and who are in a special day class or who do have push-in or pull-out minutes, the IEP must still be appropriately ambitious in light of their circumstances. So every student's program, it can't be just aimed at this trivial progression, because that would be a denial of faith. And this case, NJRF, is especially important in IEP meetings because it requires the team to discuss the student's unique circumstances, their current performance, their expected progress, and whether proposed goals and services are appropriately ambitious for that child. In terms of parental rights, in Winkleman versus Parma City School District, the court held that parents have independent, substantive, enforceable rights under IDEA that are completely distinct from their children's rights. So because parents are right holders, parents have the ability to prosecute IDEA actions in federal court themselves. So this emphasizes that parent participation is built into the law and is very important. And so in meetings, we usually ask whether the team has actually considered parent input or merely allowed the student to speak. The record, the meeting notes should reflect what was considered, what was accepted, what was rejected, and why. In Schaefer versus Weiss, the court ruled that the burden of persuasion in due process hearings under IDEA basically rests upon the party seeking relief, usually the parents. So if you're the one that files the lawsuit, files the due process, it's on your burden to prove whatever your claims are. And so since parents usually carry the burden, because they're usually the ones filing due process, building a very strong record during active IEP meetings is very, very important to prove that a district denied your child a FAPE. And so the IEP meeting is often where the future hearing record begins, because for example, if a parent requests an evaluation, a particular service, a particular placement, or any sort of data or data review, we want to make sure that that request and the district's response are documented clearly in the IEP. In terms of unilateral placement and reimbursement, so under Carter and Forest Grove, these cases establish that parents can choose to place their child in a private school and basically get reimbursement from the state. And so there's a 3-part test to this. First, did the school fail to provide a FAPE in a timely manner? Second, is the private placement appropriate to meet the student's needs? And third, do equitable considerations favor reimbursing the parent. Basically, did the district and parents cooperate in this process? Did parents give sufficient notice to the district? So when a parent is considering unilaterally placing their child in a private school, they should always, we would recommend, of course, I'm an attorney, so it's maybe speaking a little self-serving here, but they should always they should try to speak with the lawyer to basically address the risk, notice requirements, evidence of anything that the district did, inadequacy, any evidence supporting the private placement, and other sort of equitable factors. And so, in terms of the core components of an IEP, the IEP process should follow a logical sequence. So first, the team reviews data and present levels. Those present levels of the child identify what their disability-related needs are. So you got to ask yourself, what does the current data show about the student's academic, functional, behavioral, communication, social, emotional needs? And then which one of those disability-related needs interfere with their ability to access the curriculum, to participate in the program, to progress in their setting. And so those needs drive goals. Measurable annual goals drive services and supports. And so only after those decisions are made should the IEP team discuss placement. Basically, where the IEP can be implemented in the least restrictive environment. And so many disputes come about because teams try to reverse this process. They begin with a particular program or a classroom or a service package, and then they try to justify it afterward. So whenever you see placement discussions occurring before the team has agreed on present levels, on their needs and their goals, that should raise a giant red flag in your head. So now we're going to transition to a lot of IEP issues that that special education attorneys all commonly encounter in our practice, and how to address them both during the meetings and afterwards. So the first issue is inadequate evaluation. So the evaluation doesn't basically test the student in all suspected areas of disability. If he's having behavioral issues and they don't do a functional behavior assessment, that's a red flag. If there's evidence that he or she has fine motor deficits and they didn't do an occupational therapy assessment, or the assessment itself only uses one assessment tool, that's a red flag. Another issue with evaluations is stale data. So districts rely on data from 3 years ago, or use these quick screening tests instead of comprehensive testing instruments. Children change a lot. In a very short amount of time. Progress isn't always linear, and relying on data from a couple years ago could massively over or underestimate the child's current capabilities. And so another issue is ignoring outside data. So a lot of times parents have an assessment that they got from a private specialist, say, who assessed their child for autism, or they get an independent evaluation that is given to the district, and the district doesn't use these in developing that child's plan. So questions to ask in an IEP meeting when we're evaluating a child is, what suspected areas of disability have been identified? What data, if any, supports or contradicts that eligibility? Are there areas where the team is making assumptions without actually assessing the child? Did the evaluation actually answer the referral questions that were in the assessment plan? And if the district does reject an outside evaluation, what is the basis for them rejecting that? A second issue is vague present levels. They'll often copy paste these, or they're copied verbatim from previous years' documents, and they'll often rely on like subjective anecdotal descriptions. He's doing well. He's a pleasure, and he's a pleasure in my class. She always comes with a big smile on her face. Like these are all nice things to hear, but it's not a quantifiable, data-driven metric. So another issue is basically failing to link specific baseline scores to expected progress, which prevents objective tracking. So present levels, they have to explicitly document how the disability affects the child's ability to access the curriculum. So present levels drive goals, services, and placement. And if present levels are vague, the rest of the IEP is very vulnerable. So you want to ask, what baseline data supports this present level? What is the student able to do independently, or with prompts, or with which accommodations or other supports? What data shows whether the prior IEP even worked? Where is progression or lack of progress or inconsistent performance documented? These are all things that we need to keep in mind and ask the IEP team if the present levels are enough to snuff. A third issue is weak or unmeasurable goals. So goals will often be written in language like, oh, by next year he will understand, or he will appreciate. And this kind of language doesn't define the target criteria, or it doesn't describe the evaluation tools. It doesn't have any sort of short-term objectives. You want to ask, okay, what skill is being measured? What is the baseline? So if we want him to be able to read, 5 one-syllable words by next year, how is he performing now? Is he able to read one word? Is he able to do that only when he's given prompts? We need that kind of info. And another issue is like lack of ambition. Like goals shouldn't be simply a repeat of last year's goals just because it wasn't met. If a goal wasn't met, we need to ask ourselves why, and hopefully the present levels answer that question. And if it wasn't met, maybe it was too ambitious, or maybe the level of support that they were receiving didn't allow them to receive that goal. The goals need to be appropriately ambitious based on that student's present level. So other questions we got to ask ourselves during these meetings is, exactly what level of mastery is expected by the next IEP? How often will progress be measured? By whom? And using what tool? If the student did not meet last year's goal, what is going to be different this year to allow them to meet that goal next year? A fourth issue, and this is a big one, is basically the IEP team predetermining where the services and the placement of that child. So they'll give you a draft that, like a completed IEP document, and it already has the placement choice, and the team doesn't give any consideration to parental input and the IEP team doesn't agree or even pretend to agree to alterations during the meeting. Another excuse that we hear from districts is the team will say, oh, we have a staffing shortage, or we don't have that program at our school, or it wouldn't be very convenient for the teacher to be able to do this, and these all these excuses aren't based on the student's individualized needs. It's the district just saying they can't do it for XYZ reason, and predetermination can undermine the meaningful parent participation and the procedural compliance components of IDEA that the district should all be following. So we want to ask ourselves, What options were considered? What data supports rejecting the parent's requested services or placement? Is that refusal based on the student's individual needs, or is it just because of program availability, them not having it at the school? And we always want to ask, please document. You always want to make sure that that they document the request and the reason for refusal, either in the meeting notes or in a prior written notice, which I'll get to in a bit. Another issue is the district agreeing to give a child a particular amount of service minutes without any sort of reasoning. So, I'll give you 30 minutes a week of group speech therapy, because that's just standard for what they give every child who has a speech and language impairment. But that's not an individualized calculation of what is needed for that particular student to meet their goals. When the district agrees to consultative services, so basically the service provider agreeing to speak with the gen ed or the special ed teacher for a certain amount of minutes per day or week or month or quarter, you need to specify in the IEP how those services will be implemented specifically. And so the questions we kind of want to ask ourselves, what goal or need does this particular service address? Why is the district recommending this particular frequency and duration for services? Will the services be individual or group? What happens if sessions are missed? How will the team know whether the service is effective? These are all the kinds of questions we want to ask ourselves when we're deciding how much related services a child's going to be getting in their IEP. We kind of touched on this before, but often students with disabilities get into trouble at school. They're suspended, they have severe behavioral incidents, expulsion is thrown on the table. So we need to decide. The district often tries to treat these behaviors as something that the child's willfully doing, and they're applying like the standard code of conduct that they apply to their non-disabled peers on this disabled child, rather than treating it as a manifestation of their disability and addressing the skill deficits that led to these behaviors in the first place. When a child does have a behavior intervention plan or some sort of behavior plan, often these are punitive or overly generic, or developed without a functional behavior assessment, which leads to, first of all, a poorly written plan, but also poor implementation of that plan. And accumulating suspensions, shortened school days, parental calls to pick the child up early without conducting these formal reviews hurts the child. You need to have data to instead of just saying, oh, this is a problem child, let the parent deal with it. The districts often try to do this, and this isn't something that parents should take lightly. So we want to ask ourselves, whenever there's a problem behavior, what was the function of that behavior? Why did it happen? What happened before? What triggered it? What was the staff response? What strategies is the school using both before, during, and after this particular behavior to address that child's needs? What supports have been tried in the past? Is the behavior plan specific enough for staff to be able to implement consistently? Are these removals from class, from school, are they in effect creating a change of placement? If a child's always getting suspended and he's having to be at home all the time, he's no longer in the gen ed classroom, he's no longer in the special day class. They're now essentially receiving home instruction, and without a manifestation determination meeting, that's inappropriate. And basically we need to be asking ourselves, does the behavior indicate that the IEP is not providing that child with a free and appropriate public education? Schools will often try to place students in these self-contained special ed classrooms or an entirely separate school based solely on their disability category or their medical diagnosis, rather than their individualized performance. So another issue is rejecting general education placement without considering accommodations and modifications that can be made to that child's program, like co-teaching, paraprofessionals, a modified curriculum that could otherwise support the student in the general education setting. Because to the extent we can, we want the student to be in a general education environment, and before moving them to a special day class or pulling them out, we want to add as many supports and services as we can to allow them to be successful and access a curriculum in that setting before we move them to a different class. So we want to ask ourselves and ask the team, what supports would allow participation in general education? Which parts of the day can the student access this classroom with supports? What evidence shows that the student cannot be educated in a less restrictive setting? How will the team avoid unnecessary isolation while still meeting the student's needs? So accommodations and assistive technology. So accommodations are supports that allow the student to access the curriculum, and listing these standard boilerplate accommodations like preferential seating that's not tailored to the student's unique needs and failing to define when or how they're implemented is a big problem. If it just says preferential seating, that doesn't really tell a teacher who's looking at his IEP what that means. Does it mean he has behavior issues, so he needs to be sat away like close to the teacher so she can attend to him more often? Is it is it that they have auditory issues and they need to be able to be in a quieter part of the classroom, away from the air conditioner, away from the fish tank? I mean, you need to specify in these IEPs to the extent possible how this so that a teacher who's just reading this can implement it actually, and you need to define in there how often it's going to happen, where it's going to take place. Assistive technology are things that are things like an iPad for a child who can't who has trouble communicating. So they use this communication device with picture icons, for example, or they're deaf and hard of hearing, and so they need some sort of remote technology device that allows them to the teacher's voice to be amplified into a device in their ear. The schools have an obligation to not only provide these supports when needed, but give staff training so that staff knows how to use them, so that parents know how to use them, so that the child can use them at home, making sure that these don't break down and there aren't like software or hardware like maintenance issues. So for the accommodations, we want to ask ourselves, what specific barrier to the child's ability to access the curriculum does this specific accommodation address? Who was responsible for implementation? Does the student need training to use the accommodation or the technology? How will implementation be monitored so we can make sure that these accommodations actually take place and that the child's able to get the most use out of them? Are these accommodations like consistently available across all settings? Sometimes a child will need to bring their iPad to lunch with them or recess so that they can communicate with other children. We want to make sure that the school is implementing, that the IEP is written in such a way that it's specific enough so that any staff member who's reading this can make sure it gets implemented correctly. Transition planning for students who are 16 and older, really when a child starts to enter high school, but especially once they turn 16, we want to start thinking about, okay, what is life after high school going to look like, after they're out of this educational programming? So the district's supposed to develop transition plans, include appropriate transition goals, give them resources for colleges or vocational training, things like that. And a lot of times schools will just develop these very superficial boilerplate transition plans with generic goals, like he will get a job, she will write a resume, that aren't really based on like any sort of assessment data or tailored to that student's unique interests. Another issue is disconnected programming. So failing to align that child's coursework and transition goals, and failing to invite or coordinate with adult agencies like a person from the vocational training program. We want those people to attend IEP meetings if possible, so that the parents and the students can get specific information. So we want to ask ourselves, what does the student want after high school? What transition assessments were done to support these goals? What kind of skills do we want this child to develop this year? What outside agencies should be invited or coordinated with? Do the annual goals connect to this child's transition needs? So another huge issue, and probably the biggest one, is the district failing to implement the IEP as written. So many of the strongest cases I see are not cases that involve badly written IEPs. They're cases involving good IEPs on paper that were never actually implemented. So the written IEP is appropriate, but for example, service minutes, specialized instruction, therapy sessions, they're not delivered due to staffing shortages or scheduling conflicts or whatever other excuse the district comes up with. Districts sometimes cite like staffing shortages or these scheduling constraints as the reasons why services are not being delivered, but staffing challenges do not relieve a district of its obligation to implement the IEP. Another issue is uninformed staff. So general education teachers, special ed teachers, the support staff are often unaware of or fail to implement the students' mandatory classroom accommodations, or for example their behavior plan. Another issue is unresolved or missed sessions for services. So for example, speech or occupational therapy or behavioral therapy or mental health counseling. These sessions are missed, and the school fails to document these missed sessions or provide any sort of makeup or compensatory services. Another issue is that progress reports do not match classroom reality. The teachers will tell you that, yeah, he was able to meet his annual goal, and you think to yourself, great, but if that doesn't really match with what the parent is seeing at home, parents always have the ability to ask for the actual data. I want to see what test or what how you came to this conclusion that he met his math goal, that he met his reading goal, that he met his behavior goal. These are all things that we want to like keep in mind, just to make sure that the team actually implements the IEP. And so I'll give a few strategies basically for how to handle these issues. So prior written notice is basically a written document that the district provides whenever it proposes or refuses to change a student's identification, evaluation, or placement. So every prior written notice has to include the proposed or refused action, the reason for that decision, any data or evaluations or records that the district relied on, alternative options that were considered, the basis for the district rejecting or granting your request, and then procedural safeguard notices. So a well-drafted prior written notice like clarifies disputes and locks in the district's defenses. So a vague, incomplete, or a prior written notice that wasn't even given, these things could all indicate like procedural violations that can strengthen a parent's case in due process. So a well-developed prior written notice can clarify disputes before the child or before the child's parent decides to file a complaint with the California Department of Education or file for due process with the Office of Administrative Hearings. And a vague or incomplete prior written notice can reveal weaknesses in the district's decision making that can then be used against the district. So this says attorney meeting tactics and advocacy, but this is something that all parents can do themselves. So before the meeting, you want to be able to review all the evaluations, the progress reports, the data, discipline logs, any communications that were done either formally or informally, like through email. You want to be able to write out your concerns, submit them before the meeting to prevent any sort of predetermination, and establish a clear agenda. So something that I like to do in my practice is basically before going into a meeting, sending the IEP team an email with what the parent wants to discuss and often what we're asking to be included in the IEP, because these meetings can be long. They could jump from one place to another. It helps to keep the meeting focused, and it gives the district something in writing for them to check off. Okay, we talked about that, we talked about this, we talked about that. So before the meeting, review the evaluations, the progress reports, the service logs, the grades, attendance, prior IEPs. You want to identify what exactly it is that you are asking the district to do or not to do. You want to prepare your concerns in writing, and you want to decide which issues should be resolved at the meeting and which issues you may want to keep in your back pocket for a different time. And during the meeting, you want to keep the discussion anchored to the data. You want to ask for the district's reasoning behind any refusals. You want to, if there's anything ambiguous in the IEP, you want to ask them to clarify that for you. You want to make sure that your concerns are included in the IEP document and documented there. And you want to try to avoid letting the team skip from concerns directly to discussions of placement. And after the meeting, you need to compare the final IEP to what was discussed, request any sort of corrections very promptly, and basically if the record is incomplete or inaccurate, send a follow-up email just to make sure that written requests for corrections and compliance timelines are followed through with. So if there is disagreements with the district, there are ways to resolve these. So one option is a reconvene meeting, so asking the IEP team to meet again to address any sort of misunderstandings. Facilitated IEPs or alternative dispute resolution mechanisms. So basically where a neutral third party facilitates and helps manage the difficulty of the group dynamics. A lot of parents and districts end up developing some bad blood towards one another. So having a neutral third party kind of mediate the dispute between the parties can often lead to resolutions that maybe wouldn't have been possible if that mediator wasn't there. If alternative dispute resolution, if another IEP meeting doesn't help the process, if alternative dispute resolution or mediation doesn't help, parents or their attorneys can file state complaints in California. They're done with the California Department of Education. This is more for when there are procedural issues or the district's not implementing the IEP as written. Due process complaints, these are usually for more like substantive, like complex FAPE or eligibility placement disputes. Due process is kind of like a lawsuit that's filed in the special education context. You file it with the California's Office of Administrative Hearings. And then to the extent due process doesn't give the parent the outcome they were looking for, they could always file appeals with a federal court to basically review the decisions made by the Office of Administrative Hearing. And so the appropriate path kind of depends on the issue. These are all specific for what's going on in that particular child's case. Implementation failures, so them not implementing the IEP, that might be well suited to a state complaint. But issues having to do with whether the district gave the child a free appropriate public education, disputes about placement, disputes about reimbursement, this often requires due process. And so you always want to make sure to, talk to your lawyer and just check state-specific rules and timelines. So this is kind of just a short little checklist kind of summarizing what I've spoken about. So for you want to ask yourself these questions. Is there baseline data for every goal? You want to make sure that the present levels provide a measurable baseline against which you can track progress. And in the meeting, you want to object and have it documented in the IEP that baseline descriptions like student can do this with some help. You want to try to ask for specific percentages or frequency rates. How often does he need help? How many minutes does he need help for? Does this happen every day? Does this happen in every class? Does this happen with every subject? These are the kinds of questions you want to be, the kind of specific questions you want to be asking yourself. Another critical question are the goals appropriately ambitious? So are these goals allowing the child to make appropriate progress, appropriate for that child's unique circumstances? So review last year's goals. If the goals are repeated, ask why progress stalled, and ask if maybe we need to make the goal a little less ambitious, or we need to increase supports, or maybe the child can't access the curriculum in that particular setting. Again, these things are all very specific to that child's unique needs. Are accommodations clearly defined? This is another thing to ask yourself. We want to make sure that any sort of generic, unenforceable accommodations are fixed in the meeting, and identify who's responsible for implementation, how accommodations will be monitored, and by who. And lastly, and very importantly, has least restrictive environment been thoroughly evaluated? So we want to try to protect the students, protect students as a rule. If they can access the curriculum in the general education classroom, should be placed in the general education classroom. So we need to ask ourselves and ask the IEP team, what accommodations or modifications or services were used in general education before considering a more restrictive placement? And so, the core takeaways from my little presentation, special education law began as a response to exclusion of students with disabilities in the classroom. The IEP is a central legal mechanism for delivering a student a free, appropriate public education. Under the Andrew F. case from 2017, progress must be appropriate in light of the child's unique circumstances, and that's how we define what a free, appropriate public education means. Procedural rights protect substantive outcomes. We need to make sure that there's meaningful parental participation, that evaluations, IEP documentation is all provided before the meeting so that you can review and you're not just being expected to absorb all this information on the spot. And of course, the best IEP advocacy, whether it's your attorney or you as a parent in the meeting, you need to make sure it's data driven, it's specific to your child, and it's record conscious. So get everything in writing. That's my presentation. I don't know if anyone has any questions.
Thank you for taking a break.
I didn't want to say it on camcording this for later usage, but I thought it was great. I learned a lot of things about the history that I didn't know. Some things I did. from graduate school, but some of the case law in particular was something that was a good review.
Yeah.
Good. So that was, and I think it'll be helpful for parents
I was
to
going
see
to say
it.
you can. Just go over here.
Hi, can we test your mic really quick? Can you see? Thank you.
So if we're ready, I'm ready. Today we're going to go over independent educational evaluations. We're going to talk about parent experts and district assessments. So, independent educational evaluations and why they matter, right? They matter because you need an accurate interpretation of student evaluation data. This is the cornerstone of special education decision making. Under IDEA, evaluations used to develop an individualized education program must be, quote unquote, technically sound, administered by trained personnel, and selected and administered so as to not be discriminatory. We'll break down those a little bit more as we go through this. Independent educational evaluations sit at the center of many special education disputes because evaluations shape nearly every substantive decision underneath the Individuals with Disabilities Education Act. I'm going to be referring to that as IDEA from now on. Eligibility determinations, present levels of performance, IEP goals, placement decisions, service intensity, compensatory education, remedies all flow with how the student is evaluated. So when an evaluation is incomplete or methodologically weak or disconnected from educational impact, the result of the IEP is often similarly flawed. For parents, understanding this strategic role of evaluations is essential because disputes are rarely won by simply asserting that a district missed something or that you feel that an evaluation is wrong, right? They are won by demonstrating through credible expert evidence that the district's evaluation failed to identify the child's need in a way that allows the IEP team to design a program reasonably calculated enough in order to enable appropriate progress. That's what we're looking for, right? The appropriate progress. And then evaluations also play a credibility role, right? Hearing officers and courts often place significant weight on which evaluator used technically sound instruments, gathered data across settings, and explained how test results translate into classroom access and programs. For example, if a neuropsychological evaluation that links executive function deficits or fails to address missing assignments, slow work completion, or anxiety-driven school avoidance is something that's far more persuasive than a report that merely lists some standardized scores. Maybe like the student isn't doing too well on these tests. That's not going to be a very persuasive evaluation. And then in practice, of course, evaluations become factual backbone of arguments about faith, making them both an educational and litigation tool. So this slide in particular frames how evaluations are often the case itself, and we'll get a little bit into that as well if you're going to move forward with litigation. Then you can read evaluations critically, identify gaps, and deploy independent experts effectively, these experts are oftentimes better positioned to protect parental rights, challenge inadequate district practices, and of course secure meaningful remedies aligned with your child's unique circumstances. So the legal framework under the IDEA, there's three categories here that I'm going to go over. So it's going to be IDEA evaluation requirements, Supreme Court standards, and then evaluations under IDEA in general. And then the IEE regulation that we're going to talk about is 34 CFR, section 300.502. So you have your three categories, right? The first is your district evaluation. District evaluations are initiated, designed, and funded by the school district and are primarily used for eligibility determinations, IEP development, reevaluations, and placement planning. This is normally your first introduction to evaluations in general. The district will be the one providing it. Next could be parent private evaluation. So as a parent, you went out and you obtained an evaluator. So you selected this person, you paid for them, And then they're often used to attain sometimes a first opinion, sometimes a second opinion. A lot of times you're going to interact with it as a general practice of your child's medical care and health care. So for this one, if you're using them to obtain a second opinion, then you want to prepare for advocacy or litigation, or to supplement the IEP's team's understanding of your students' needs. Independent education evaluations at public expense, this is our third portion, occupy a pretty singular procedural space. Although selected by the parent, they're also subject to lawful agency criteria. This means only the district will only fund this evaluation if they meet this criteria. So understanding these distinctions matter because only an IEE at public expense triggers specific procedural obligations for the district. If you obtain an IEE at your own expense, then the district doesn't really have a say in what criteria or how it is that your student is evaluated by this third party. So in practice, us attorneys will often use all three categories strategically, right? So a privately funded evaluation may help identify gaps and justify an IEE request, while a publicly funded IEE can become pretty powerful evidence that the district was required to consider certain things that they may have missed. So mislabeling or conflating these categories can a lot of times weaken advocacy, particularly in correspondence or hearings. Precision in terminology helps to preserve rights and clarifies expectation for both parents and districts. So a few common ways in which evaluations are misconstrued. So why in the first place would you even need an independent evaluation, right? So a persistent misrepresentation in special education eligibility meetings is the claim that, one, low average is still average, right? So the school may be implying that a student performing at the 16th or 25th percentile are functioning typically. It is important to remember and to state in IEP meetings that low average is still a range below the average range. So rather than get caught in the semantic battle over whether low average can be rightly called below average, it might be best for parents and parent advocates to simply say below the average range. A lot of times in district-funded or district-initiated educational evaluations, they will address that a student is somewhere in the low average range and then not make that extra leap into particularly discussing the particulars of why that's occurring. So in the context of suspected specific learning disabilities, consistent low average academic skills are often signals of persistent average academic skills or underachievement relative to age peers, and then they may also be indicative of a need to influence or target a different sort of intervention strategy. A lot of times districts will not provide this intervention strategy, at which case it would be a good idea to request that independent educational evaluation. And then the concept of within general limits, I'd also want to talk about this because representing results as average, this may mislead teams, and they also may violate the IDEA requirement that decisions be based on accurate data interpretation. So a common source of confusion lies in the distinction between the concept of what is within normal limits and then what is below. Meaningful progress should of course show all of the following, right? One, of raw score growth. Two, standard score improvement or improvement in whatever evaluation strategy is being used. Then a significant increase in percentile scores, mastery of critical foundation skills, and response to scientifically based interventions. A student who is still remaining at this 10th percentile year after year is not progressing adequately, even if the percentile is something that's stable. So remember, we're still looking for meaningful progress, and this is a lot of times indicated by percentile ranks. So percentile ranks reflect relative standing, not growth. Maintaining the same percentile means the student is improving at roughly the same rate as peers, but eroding the gap between that student and her peers, not eroding it least, right? So courts have similarly rejected arguments that slow, trivial, or non-closing progress meets FAPE standards. All right, we'll keep going. So IDEA evaluation requirements and Supreme Court standards. Since I brought up the Supreme Court, let's keep talking about them. So the IDEA imposes clear substantive requirements on school district evaluations. Districts must assess a child in all areas related to suspected disability. They must also use technically sound instruments, and they must ensure that evaluations are sufficiently comprehensive to identify all special education and related service needs, regardless of a disability label. So these evaluation duties are interpreted through broader Supreme Court standards governing FAPE. In the Board of Education versus Rowley, the court emphasized procedural compliance and educational benefit, setting an early baseline for adequacy. Adequacy. More recently, Andrew F. versus Douglas County School District clarified that an IEP must be reasonably calculated to enable progress appropriate in light of child circumstances. This is rejecting minimal or de minimis progress. Evaluations are often are the foundation upon which these standards are applied. So if an evaluation fails to identify key needs, then the IEP team cannot design an appropriate program, right? If the IEP team cannot provide or design an appropriate program, then the district is risking violating FAPE. For attorneys, tying evaluation deficiencies directly to these Supreme Court standards strengthens our arguments a lot of times if you choose to seek an attorney or any legal support, that procedural and substantive violations are intertwined. So an incomplete evaluation is not a harmless error when it derives the IEP team of information necessary to design a program that enables meaningful progress, right? It's not a harmless error. Let's keep going. The IEE regulation, this is that nice little statute that I had brought up before. So the core regulation governing independent educational evaluations is 34 CFR section 300.502, right? This provision gives parents the right to obtain an IEE if they disagree with an evaluation obtained by the public agency. So we already talked about why you might disagree. Maybe the evaluations are not showing progress. Maybe the evaluation was done poorly. So importantly, the regulation also does not require parents to prove that the district evaluation was inappropriate before requesting an IEE at public expense. So upon receiving such a request, the district generally must either fund the IEE without unnecessary delay or file for due process in order to defend the appropriateness of its evaluation. Districts may ask why the parents disagree, but they can never require an explanation or use the lack of one to delay processing the request. The regulation also, and what we mean by processing the request is providing that answer, right, of whether or not to provide the funding or to not provide the funding. So the regulation also allows districts to establish criteria related to evaluator qualifications, location, and cost, but only if these criteria mirror what the district uses for its own evaluators and do not, of course, infringe on the parent's right to an independent assessment. For practitioners, mastery of this regulation is critical. So any precise written requests that cite the regulation and clearly state disagreement help prevent unlawful delays and, of course, preserve remedies when districts fail to act appropriately. So the strategic use of parent experts, this is when parents should obtain their own expert, how to choose the right expert for IDEA purposes, and then common categories of parent experts. So when should parents obtain their own expert? So parents or parent-side counsel or parent-side advocates should consider retaining an independent expert when there are red flags, suggesting that the district's evaluation does not fully capture the student's needs. Common triggers include evaluations that are narrowly scoped, omit suspected areas of the disability, or rely heavily on grades and teacher observation despite inconsistent performance. For example, if a direct evaluator stops an academic achievement test after a number of incorrect answers in a row, the fact that a student reaches the maximum amount that they can do does not exclude or cheat that student out of a better score on that test. The standard scores and percentiles of all tests are derived from how all students fare with exactly the same test challenges, and the progressively more difficult prompts on academic achievement tests highlight how poorly students would still do in the absence of such prescribed ceilings. So experts are also critical when districts find students ineligible despite significant, ineligible of course for special education services, despite significant clinical, behavioral or academic concerns, or when IEPs offer minimal services, generic goals, or no related services in the face of documented need. Situations involving limited progress, regression, school refusal, anxiety, escalating behavior, or disputed placements often benefit from independent expert input. So from a litigation perspective, experts may be needed in order to address methodology, causation, educational impact, compensatory education, or the appropriateness of a placement change. The decision to obtain an expert should be strategic rather than reflective, right? It should also be guided by the expert's findings and whether or not they will advance eligibility arguments, service claims, or remedies. And then early expert involvement can also shape the narrative before positions harden, influencing IEP discussions and preserving issues for due process. So how do you choose the right expert for IDEA purposes? Reliable versus unreliable evaluations. I just want to break that down really quick. So reliable evaluations would include those that go over standardized administration of testing, strong reliability coefficients, clear construction definitions, use of multiple measures, documentation of testing conditions, interpretation consistent with any publisher or leading manuals. And then what are the red flags, right? This is what you're really looking for, is that maybe testing was stopped due to a time constraint, or are there missing subjects or subtests needed for diagnostic profiles? Also, using non-standardized tools as evidence of grade level functioning, and then of course, over-reliance on subjective teacher reports. Selecting the right expert is about relevance and credibility. It's not simply credentials, right? All of the evaluators for the district are credentialed, and they, of course, can still be wrong. So the most effective experts understand how to connect assessment data to IDEA-specific educational needs. Attorneys, we evaluate experts based on scope, right? Ensuring that they can assess all of relevant domains or coordinate with other specialists as needed. School reliance is also essential, and experts should understand IEPs. They should understand eligibility categories, accommodations, services, and placement options. So strong experts provide specific, measurable recommendations that are tied directly to the data rather than vague suggestions. And independence is also another key factor, right? Experts are perceived as advocates rather than neutral professionals that may be discounted. And then, of course, lastly, anybody seeking experts should also consider whether the expert can support remedies by quantifying compensatory education or explaining why a particular intensity or placement is necessary. And then thoughtful expert selection strengthens both educational outcomes and litigation posture if it gets there. So we're going to go over now the common categories of parent experts. If you have been around special education, you have probably dealt with some of these. So you can get expert types anywhere from neuropsychologists, speech-language pathologists, occupational therapists, and then BCBAs. This is not an exhaustive list, but it's just some common experts that parent-side cases often involve, right? So neuropsychologists frequently assess cognitive functioning, executive skills, learning disorders, ADHD, autism, and the emotional impact of disability on learning. Educational psychologists focus on academic achievement and processing deficits tied directly to school performance. And then speech and language pathologists evaluate expressive, receptive, and pragmatic language needs that affect students' classroom participation. Occupational therapists assess sensory processing, fine motor skills, and access issues. And then BCBAs are board-certified behavior analysts that critique functional behavior assessments and behavior intervention plans. So mental health professionals in total should address anxiety, trauma, emotional disturbance, and then any student experiencing school refusal as well. They should also address those issues. And then assistive technology specialists are somebody that is also included, but I did not include on the expert type list, but they're somebody that is often involved, especially when you have speech and language needs. So assistive technology specialists evaluate access to communication, reading and writing through devices and software. Transition and vocational experts, if your student is a little older, also support post-secondary planning. So understanding all of these categories can help you to match the expert to the question at issue, right? And then what should you look for also in an IEE or district reports involving these experts? It's look for that full summary of your student's history. Also, any identification of discrepancies across measures, interpretations consistent with any founded and sound theories, and then use of diagnostic measures, comparison to typical growth trajectories, and then of course also explicit recommendations, right? These reports should not be generalized. You should be looking for these recommendations that are specifically linked to your student's data, discussion, or whether or not the school's programs are actually adequate for your student. And then of course, is the data representative of the student's actual ability, right? Evaluators should consider testing conditions, student motivation, fatigue, medication, right? They should also show whether or not scores are consistent across all domains, and then also look at contextual factors, right? We're looking at language status, we're looking at attendance, we're looking at trauma as well. And then representation ability requires triangulation across all measures. It's not just cherry picking of favorable results. Okay, so you requested an independent educational evaluation. The district has agreed to pay for it. So to go through all of that process, we're going to talk about triggering and then requesting this IEE, the district obligations and the common improper responses, then all public expense, what that means, cost caps, and then district criteria. District criteria, I can't go into depth with it because if you're in a different district, all of that criteria is going to be different, but I will talk generally about it, right? So triggering and requesting an IEE at public expense. A parent's right to an IEE at public expense is triggered by disagreement, written disagreement with a district evaluation. It can also be verbal, however, I think for posterity's sake and also keeping your own records, just write an email, write a formal email. So the disagreement does not need to be elaborate or technical, but it must be clear. Best practice is to submit, of course, that written request, identifying the evaluation date and the areas of disagreement. Clear language also helps to prevent disputes about whether a request was made and starts the clock on the district's obligation to respond without unnecessary delay. That is the amount of time that unfortunately the district has, is without unnecessary delay. And there are a few case laws out there that try to define what this means. Right now the average is about 90 days, right, without any communication whatsoever, but the standard is unnecessary delay. And then if you're seeking guidance with an attorney, then just ensure that your attorney is helping you to be precise and timely, and then also ensure that the request is framed as a statutory right rather than a negotiation, right? So any properly drafted requests also preserve arguments that later delays or any denials constitute procedural violations, and then that those also impede parental participation in educational planning. And as you learned previously, you have the right to parental participation and then also the right to plan your child's education. So district obligations and common improper responses. Once a district receives a valid IEE request, right, remember valid is just clear, it's preferable that you write it, but if you make that verbal request, make sure you note that for yourself and continue to keep track on it. But once they receive a valid IEE request, it typically has two lawful options, right? One, they either fund the IEE subject to the criteria, or they deny it, right? And if they deny it, you'll likely get a prior written notice, or sometimes they may even file for due process to prove that its evaluation was appropriate. So districts may not ignore requests. They require parents, districts may not ignore requests. They also may not require parents to justify their disagreement. They may not insist on additional meetings as a precondition. And then they also may not force parents to use district-selected evaluators, right? At the end of the day, it's your choice. As long as your evaluator falls within their criteria, then you're good to go. Improper responses often also include delay tactics, but remember that the district has a reasonable amount of time to respond. So if you're hearing absolutely nothing from them and it's been 4 months, then that is an improper delay tactic. And then also misstatements of the law or attempts to narrow the scope of the IEE without any justification. So identifying and documenting these missteps is critical, as procedural violations can strengthen claims for reimbursement, right, compensatory education, or other remedies that may be required in order to make your child's education whole, or student's education whole. And then prompt follow-up and written clarification requests help to also hold districts accountable to their obligations. So we'll talk about public expense, right? The cost caps and then the district criteria, but like I said before, I can't really go into specifics for whatever district you fall in. They're a little bit different, or they can be. So the term public expense generally means that the district pays the full cost of the evaluation or otherwise ensures that it's provided at no cost to the parent, right? These disputes in this area frequently arise over what costs are included, such as testing time, report writing, record review, classroom observation, sometimes even evaluator travel, and then also participation in the IEP meetings. Districts often maintain IEE criteria. This includes evaluator qualifications, geographic limits, and then rate schedules, and that's your evaluator's rate. These criteria must mirror what the district applies to its own evaluations and cannot be used to control the substance of the independent opinion, right? That's the point of having an independent opinion, is that the district does not have their hands in it whatsoever. So, except for, of course, paying for it at public expense. And then cost caps are often also a common flashpoint. This is particularly when students have complex profiles requiring specialized expertise. So if you're working with an attorney or you're working with an advocate, then they should assess whether exceptions are warranted based on the child's needs, the availability of qualified evaluators, and then, of course, whether or not the district applies similar limits to itself. You can also check that for yourself as well if you're not working with an advocate. And then effective advocacy in this area is factual and evidence-based rather than rhetorical. So using evaluations as persuasive evidence, building the record, and examining experts, and then hypotheticals and final rules of thumb if we are going all the way, right? We're going to litigation. So an expert report is most persuasive when it answers the issues the hearing officer must decide, right? Some of these issues include what did the district know or suspect, what did the district evaluate, why did the district fail to evaluate, and then why did the omission matter educationally? How did the omission affect eligibility, or IEP content, or services, placement, progress, or even behavior? And then what should the district do now? So when we're using evaluations as persuasive evidence, the evaluation only becomes persuasive evidence when it answers the questions a hearing officer must decide, right? Effective expert reports explain what the district knew or should have known, what it evaluated or failed to evaluate, and why those omissions mattered educationally. They connect deficits to concrete impacts on eligibility, IEP content, services, placement, or even progress. And they also articulate what the district should do now. So common theories for challenging district evaluations include incomplete scope, invalid methodology, over-reliance on limited data sources, also failures to consider outside information, predetermined conclusions, stale data, and then a lack of functional analysis as well. So if you're working with an advocate, or if you're on your own, or if you're also working an attorney, then you yourself should help experts to frame findings in a way that aligns with the Andrew F. standard, right? Emphasizing how appropriate progress can only occur if identified needs are addressed through specific supports and services. And then we'll also go over building the record and examining experts. Full disclosure here, I've never actually examined an expert, so I'm just going off of what I've heard, what other attorneys have told me, but strong cases are built on a clean and deliberate record, right? Deliberate record. Counsel should request evaluation protocols, raw data where appropriate, and then documentation of suspected areas before evaluations occur. So providing private reports strategically before IEP meetings allows the team's response to be documented through prior written notice. During hearings, direct examination of parent experts should cover qualifications, referral questions, methodology, findings, any educational impact, or critique of district evaluations, and then of course, lastly and extremely importantly, any recommendations, right, moving forward. So cross-examination of district evaluators should often focus on omitted domains, right? What did they fail to include? Ignored concerns, lack of observation, and failure to link scores to educational impact. Throughout, attorneys should tie testimony back to the legal standard of progress appropriate in light of the child's circumstances. And then we can also talk about some hypotheticals and some final rules of thumb. So common hypotheticals illustrate recurring disputes such as students who may have had good grades, but they also suffer from significant anxiety and executive functioning deficits, right? Districts offering their own so-called independent evaluators, or cost cap conflicts, or even private reports that are nominally considered but also substantively ignored. All of these scenarios highlight practical rules of thumb. If you disagree early and you disagree clearly and you do so in writing, or if you're going to do it verbally, which we do not recommend, we recommend that you follow and do it in writing, define the domains to be assessed. They also control the referral question to experts. And then you can also demand written IEE criteria, right, from the district. If the district is going to place restrictions on who it is that you can go to in order to get this independent evaluation, you can request written or some sort of documentation outlining those criteria. And then also to connect data to remedies. So ultimately, independent evaluations are not merely second opinions, right? When used effectively, they translate a student's lived educational experience into the legal framework required to prove inadequate evaluations or inappropriate IEPs or insufficient services, even improper placements, or even the need for compensatory education. Okay, and thank you. The key takeaway I would like you guys to get from this is accurate interpretation of assessment data is fundamental to ensuring students receive appropriate educational services. Misrepresentations and evaluations can lead to inadequate programming and, of course, legal noncompliance. Do we have any questions?
I would like to tell everybody, one, I think all of the attorneys for the firm did an excellent job in presentation today. This is the last presentation for the day. I want you all to know that if you want to find these presentations, we're going to be making them available on our portal through our website, and we're going to be providing further educational resources on our website through a subscription basis. But for everybody who attended today's, we are providing these free of charge. So we hope you guys enjoy the education and the educational materials. We hope you enjoyed the presentations. We look forward to putting more of these presentations on through the years and building our portal of resources for our families and our community. And we just thank you for all being a part of the community, and we thank you for letting us be a partner with helping you with your advocacy for your kids and your families. Thank you so much. We look forward to seeing you in our office or in the community anytime in the coming years.
Okay, just start the end. Is it? Can I end it?
Yep.
Okay.